her pain? It sure did. And did he have the intent to touch her that caused pain? And it did. He did that. Now he's guilty of it. So I know that if he's not in jail, I know that he's able to work and be successful and take care of himself. He's not been a drain on society in terms of that. He's not a lazy man. He's not a stupid man. So I think when he's not in relationships that he should not be in, and this had nothing to do with drugs or alcohol, he's just a good person, and he means well and he does well. And this was not a relationship either. There was not a relationship between these two. That was more of a working thing.
That's what's weird, is because in the criminal complaint, the probable cause, which comes from the police report, it identifies her as a girlfriend. It identifies her as something over a period of time, where this could have been something what could have occurred over multiple other incident dates.
And I suspect that I'm just suspecting when Attorney Renicky was going through this and charging this out or whatever, maybe he had contact with the victim in this case, and maybe she also said, I was not in a relationship with him at this time period.
Well, and I will go over to the district attorney now to ask from their perspective, because I'm going to say quite clearly in the criminal complaint, which comes from the police reports, which comes from their investigation, which comes from the statements from the witnesses and the victims, it states she is the girlfriend. It states on September 6, 2024, I, Deputy Henry, was requested by dispatch to respond to. Dispatch advised that probation agent Lineweber was at the residence looking into allegations that Bradley Scheuer assaulted his girlfriend, JEC, last night. And if you go down, it says in the middle of the paragraph that she was worried about further retaliation from Bradley, as he told her numerous times that he knows people and he can hurt her even if he's in prison. And where else did it say? He threatened to burn her alive in the camper. Where else does it say other things like that? But
the defense agrees that that's in the complaint, but again, I don't think that she's saying that.
Wow. Even from the start, the tone feels off. The defense is bending over backwards to redefine the relationship as just work, while the complaint clearly says the victim called him her boyfriend. This is already a red flag. Whenever a defendant fights harder about labels and actions, something deeper is going on. And notice how calm the judge stays. She's letting them talk, but you can feel she's already connecting dots.
She was in a relationship with him. The only thing that I had read from it is they were investigating allegations that Scheuer assaulted his girlfriend.
Schmidt?
I'm the one who charged it. The reason it doesn't have the domestic abuse surcharge is boyfriend, girlfriend is not something that creates the domestic abuse surcharge in Wisconsin. It's whether they're married or reside together or have children together. Being boyfriend and girlfriend does not make it a domestic abuse offense in Wisconsin. That is why I did not.
Well, and quite honestly, whether or not he's guilty of the charge and how it is charged doesn't really matter if it's boyfriend or girlfriend. Well, granted, if it is a girlfriend, you probably should care for that person and not want to harm them, but you shouldn't want to harm anyone. So, Mr. Davis, I don't know. I don't know if it's a girlfriend. I don't know if it's not a girlfriend. I don't have the victim here. I don't believe in court here today. I just know what was reported to law enforcement. And I don't believe that law enforcement would make something up and put that in a police report. And that's where we get the criminal complaints and the information from.
Well, just
law enforcement.
In my argument, Judge, my client was not in a relationship with her when this occurred. And it's my belief that I think that she did live in Minnesota too at the time. They were not residing together. At least that's what I believe. And so I don't believe it was a domestic relationship as defined by the statute. But in any event, I'll concur. I don't care if a person's in a domestic relationship or not. If you touch someone without their consent and it causes them pain, it's a crime, and it doesn't make it any, well, I guess I agree with you a little bit on that too. I guess if you're in a relationship with somebody, there's a tie where you wouldn't want to hurt that person, but still, it's not good, and it's why there's a law, and that's why now he's convicted of a misdemeanor because of it.
And I'll also point you to page 3 of the criminal complaint where JEC also stated there have been times while they were staying at her residence in Minnesota where Scheuer has struck her, but she has never reported it. JEC stated when Scheuer had kicked the front of her knee last night, he told her that it only takes 10 pounds of pressure to break it, and she will not be walking out of there. She would be crawling out.
And again, I think the criminal complaint in Wisconsin, they're mere allegations. I think in the discussion.
This part is brutal. These aren't minor threats. These are violent, terrifying, calculated statements. Talking about breaking her kneecap with 10 pounds of pressure or threatening to burn her alive. That's not someone losing their temper. That's someone thinking these things through. Hearing the judge read it out loud really exposes the danger the victim was in.
Or if you get body cam footage, or you get also stuff from the victims writing in themselves, a lot of the times, I would say most times it's different from what's in a criminal complaint.
I'm just pointing to the fact that JEC was saying that there was some type of relationship, whether or not
doesn't give a time, but I'm just saying, I don't believe that this was a domestic relationship as defined by the statute, but in the state has not charged him as such. But in any event, going forward, Judge, he's got the 164 days that he's sat. I know that I think the jail does have an effect on most people. I've had clients where they don't really care. Bradley does care. I know that he's climbing the walls. I know that he'd rather be out working and just doing normal things that people do out in the community rather than sitting inside the jail cell. And so for that, I think this has affected him. Again, I've got clients where they really don't care. Jail doesn't scare them. A prison doesn't scare them. But in this case, Bradley, it does. And so I'd ask the court to consider that 1 month to the 3 month. I'd ask there to be time served on that. And again, probation, it's not that I don't think probation is, I mean, it's not, I don't think that probation is not a good thing in this case, but with regard to for drugs and alcohol, I think that certainly I think probation is important. People can have some kind of monitoring, and I think they can also get involved in a lot of treatment, whether it's inpatient or outpatient through the probation agents. But in this case, he's never going to be having contact with JC again. And that whatever relationship the court wants to think that is, there will never be a relationship between those two. And for that reasons, I'd ask the court to consider my argument.
This shift is wild. The defense is talking about work ethic and how jail scares him. But the thing is, fear of jail doesn't equal innocence. And the judge knows that. It's almost uncomfortable to watch because you can see the system trying to treat him fairly. But his actions, they keep pushing back against that.
Scheuer, I'm now going to give you an opportunity to make any statement that you wish to make. You don't have to make a statement. You don't have to say a thing, but it's your only opportunity to clear anything up, to let me know anything about yourself that you wish for me to know, fill in gaps, fill in holes, whatever you wish to do. But again, you do not have to make any statement if you do not wish to.
I don't know if you ever read this statement. I wrote a statement of all the work I've done for her when I was at her house. I did a lot of work for her. My job for her was.
I'm going to stop you right there. First, I don't believe that was filed with the court, so I have not read it.
Okay.
Second, you just need to speak a little bit slower. My court reporter takes everything down, and it's very hard to take things down when we speak really fast, okay?
You can read it if you want. It's your.
Well, that looks like a lot of words.
Yeah, I don't know, I could give it to the courts,
And
but
here's the question though. What relevance does it have what work he did for this individual?
Judge, I just think he wanted to impress upon you that the relationship was that of a working relationship. I think we've already got to the point.
What relevance does that even have?
Well, I think it does because the court brought up on multiple occasions that.
I'm just bringing up what's been alleged in the criminal complaint and how it was portrayed by JEC to law enforcement and how it was placed in the police reports. And Mr. Scheuer was asked at the date of the incident as well, and he didn't state counter statements to that fact. And then it was charged that way.
Judge, I'm not going to get involved. It says allocution. I really don't know what the I don't know what the limits are on an allocution, so I'll just stay out of that.
He can tell me anything he wants to know, but I don't need to be read every time you've done work for JEC and what it was. If you've done a lot of work for JEC, you can let me know you've done a lot of work for JEC and give me an idea of what it is you did for her.
I did a lot of work for her. I put up garage doors, put up garage door openers, cut down trees because I was supposed to roof her house. The whole key was to roof her house. That was the whole key of that, because she was dating my best friend. That's how I met her. She was with my best friend. That's how I met her. And then I went over to roof her house and I told her I wouldn't roof it until I cut down all these trees. And I cut down some pretty big trees. And otherwise, that's about all I got to say. But a lot of things she did when I was there, she would get upset. Wrong word, whatever. She would get upset at you. And I've had her throw oil on me. I've had her throw water on me. I've had her get mad. She get mad if you said the wrong word or did the wrong thing. She abused me with a fence post. And I got pictures of that.
And here it is, the defendant's moment. And instead of remorse, it's excuses, lists of chores, why she made him upset, how she supposedly abused him. It's textbook deflection. No accountability, no emotional awareness. It's like the only thing he cares about is proving he was right about the relationship label.
So did you ever sleep with her, have sexual relations?
Yes.
Yes. So that answers my question. That's all I needed to know with regards to girlfriend, no girlfriend relationship, no relationship. Doesn't matter if she was dating your best friend or not, you slept with her. So it means to her that you had some.
The second he admits they slept together, the judge instantly shuts the argument down. That's the moment she knows he's been dancing around the truth the whole time. It's so subtle, but such a turning point. She sees exactly who he is.
Type of relationship.
Yeah.
Closer
Sex buddy.
than just, because I'm going to tell you, I don't sleep with my roofing guy. I don't sleep with the guy that fixes my garage doors. So it means that it was a little bit different than just a hired hand. All right. But anything else you want to let me know?
No, I'm good.
Okay. So all I heard there was excuses, 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 blame the victim, victim blaming, more victim blaming, and excuses. That's all I heard from you, Mr. Scheuer. I didn't hear any remorse. I didn't hear anything about that you're sorry that this happened. You should have never laid your hands upon her. No matter what, I'm going to tell you, even if the sky was purple and grass was blue and she got mad at everything that you did and she threw a brick at your head and caused you a concussion 6 months ago, even if she did that, okay? You had absolutely zero right, zero legal right, zero moral right, ethical right, all the rights to lay your hands upon her on September 6, 2024. Doesn't matter what she did or didn't do prior to that date, you had no right to touch her in any way, shape, or form. You had no right to lay your hands upon her. And some of these statements that she stated that you told her to law enforcement, OMG, like they are out of this world crazy. A crazy man says those things. How much pressure it takes to break a kneecap, and that she will be walking. What else did you say? I read it on the record already. These statements, these are more than just threats of harm. They're threats of egregious harm, more than substantial harm, malice, total torture. And you have no remorse. And you're not even looking at me right now. You're looking some other way because you're pissed off because I am telling you like it is. And you're mad because you wanted it to go your way. You wanted it to go your way. And it doesn't matter. It truly doesn't matter in the scheme of life and in the scheme of the legal realm, whether or not she is your girlfriend, or if she is a friend, or if she is a person on the street, or if she is somebody that hired you. In the sense of the legal word, you had zero right to place your hands upon her and to batter her. No right, but you did. Now, so that makes this serious. The fact that you have the criminal history that you do, you have an extensive criminal history, you have a crime that you're going to be sentenced for, not today. I'm not sentencing you today on that. For one, because you don't have an attorney, and you probably can apply for the public defender now since you are in custody. You don't have a job. I don't think you have income coming in. So you probably will qualify. And you need an attorney because the recommendation is prison. So that could be scary. And the second reason is because I think you need some time to let everything sink in, because this is serious. The other crime in the 23 CF 213 is significantly more serious because someone died.
This is where the judge unleashes years of courtroom experience. Her rant isn't anger, it's clarity. She's spelling out something society often avoids. No matter what someone throws, says, or does, you do not get to use violence. And the way she breaks down the threats, the way she emphasizes torture, she's not exaggerating. She's calling behavior what it is. Watching the defendant look away while she talks just makes it worse. He's not listening. He's annoyed he got caught.
And you sit there cocked back in your chair like it doesn't matter. And you have an attorney who's excellent, by the way. Who's excellent. An excellent attorney can't get the most guilty person out of the charges. Because you don't just catch charges. You commit crimes to get those charges. You committed crimes to be charged with these criminal acts. I have to look at the community and protecting the community. And Mr. Schmidt was dead on the money when he said, 3 days. I sentenced you to probation in 3 days. Within 3 days, you committed these crimes. And you're reading something, and Mr. Davis, I don't like that you're writing stuff to him while I'm doing it, or whatever's happening, because he's not paying attention.
I'm paying attention. I can hear.
No, because quite honestly, people can't really multitask. You can't read and listen at the same time. It's proven. All right. So this is important because this is your life. So I don't know what is more important than incarcerated, or whether or not you can walk free, or whether or not in another case you're going to go to prison, or whether or not you can have jail, or what's going to happen here and there. Because this moment is important. It should be the most important moment of your life. It took you 3 days on probation before you were arrested for these charges. Okay, Mr. Davis, I don't know what that is. Can you please turn it around, because he's not paying attention.
Sorry, Judge, I didn't write that. That's not my writing. But no, I don't know what I was just looking because it was there. So I'm sorry.
I don't know what it is. If it's a statement and he wants to read it, he can surely read it, and I will wait and I will hear.
Oh, it's not a statement.
Because this is extremely important. And I believe it's important. It's important to you. It's important to me. It's important to the state. It's important to the victim.
This ending is chilling. 3 days after probation, 3 days, he commits these new crimes. And there's another case where someone died. The judge isn't being dramatic. She's trying to protect the community from someone who has shown over and over he doesn't care who gets hurt. The weight of her words hits hard. This might be one of the most important moments of his life, and he still isn't paying attention.